Good afternoon, everyone, and welcome to the first in a new series of webinars with our legal partner, A&L Goodbody. My name is Zara Duffy, and I am Head of Northern Ireland at Chartered Accountants Ireland. Today's webinar is a timely and important update from Rob Tubman and Johanna Cunningham from the employment team at A&L Goodbody. We're hopefully nearing the end of the COVID-19 pandemic, but much of the uncertainty that it has created for employers, unfortunately, still remains. One thing that we do know for sure is that the workplace landscape has changed. Before the pandemic, things were changing. Technology was changing how we work, and last year has shown that we can work remotely. So after a year and a half of home working, employers and staff will have seen some advantages and disadvantages to remote working. Some will be hesitant or perhaps even fearful to return to the office, while others will want that face-to-face interaction. A new blended hybrid working model looks set to become the norm, and that creates plenty of issues for employers. So what are the key considerations for firms facing this transition? What is best practice guidance for the post-pandemic workplace? Today, we'll get an overview of these issues and more from two experts who I know have been extremely busy looking at these issues as the job retention scheme comes to an end and employers look to move safely into a new phase of working. So please feel free to put your questions into the Q&A box at the bottom of the screen. The Q&A box is open now, so please feel free to type them in there. Can I ask if you please can keep your questions general? Rob and Johanna can't answer any specific legal queries during a webinar, but we will share their contact details with you should you wish to contact them directly with some more detail. So we have a lot to get through, so let's get kicked off. I would like to introduce you to Rob Tubman and Johanna Cunningham. Over to you guys. Thank you.
Thanks very much for that introduction, Zara, and good afternoon, everyone. I suppose we'll probably start with the most recent and topical change, and that was the end of the furlough scheme. And that first slide just shows the most recent changes. So at long last, furlough has come to an end as of the end of September. That said, there are still certain admin dates to be mindful of in terms of submitting final claims and then the deadline for corrections to claims. But after a couple of extensions, furlough has come to an end, and now we have to sort of consider what comes next. And as you see on the slide there, we've set out the key things that we think employers will need to be mindful of. I suppose first things first, it's worth pointing out that as at the end of furlough, estimates were that there were about roughly 1 million people still furloughed from their jobs. So while that was a fairly significant drop in terms of the numbers that were on it, certainly early summer 2020, around May, there were over 9 million people furloughed. So there has been a significant drop, albeit 1 million is still a significant number. And the reality is that a lot of those people may find themselves out of jobs now that their employers can't benefit from the furlough assistance anymore. And we've set out some steps that we think will need to be considered, and with a view to avoiding redundancies, but accepting that actually, depending on your sector, that may be unavoidable. And the first one there is returning to work on your previous terms. So fingers crossed, furloughs come to an end and you are just able to hop back into your role and continue as if it never happened. I think that's probably wishful thinking in a lot of cases. The second one there is returning on new terms, where maybe an employer has said, okay, we'd love to have you back, but the reality is either our business model or possibly the role that you were doing previously has changed, or economic circumstances are such that we need to make a change to your terms and conditions. I guess then you're looking at, if it's a case of changing contractual terms and conditions, consulting with employees and ideally getting their buy-in to accept those. The third one there is a temporary reduction in hours. And this is something that we advised on before the furlough scheme came into being, around sort of short-time working or layoffs. That will generally depend on your contractual ability to do it. And it's something that, again, with the safety net of furlough gone, some employers may be forced to go back and revisit. And then the last one there, which we said, is the one you really want to avoid at all costs, but probably will be a reality in some cases, is running redundancy processes. Now, the reality is that some employers will have already done that before a furlough came to an end, but some will now have to actively consider it.
So as Sarah mentioned, COVID-19 has signalled a sea change to the employment relationship. And this is clearly evidenced through the latest pandemic buzzword, hybrid working. I'm sure you've all heard a lot about hybrid working over recent weeks and months. I've set out on the slide an overview of the hybrid working process that we at ALG believe is the most comprehensive way of introducing hybrid working with a degree of sustainability. I'd like to point out, first of all, that hybrid working is not the same as statutory flexible working. So statutory flexible working is employee-led. It is governed by tight statutory requirements. So for example, you have to have 26 weeks qualifying service, and you can only make one flexible working request in a 12-month period. In contrast, hybrid working is employer mandated. So we believe that hybrid working is controlled by employers. Obviously, this is then subject to internal discussion with key stakeholders and managers. It's very important that management have bought into any hybrid working model that you're planning to introduce. After this, then, of course, you will need to consult with the workforce and bring your employees up to speed with your plans for a return to the office. Next, we believe it's important that you have a trial period. So a trial period for hybrid working could be fixed or it could be fluid. Again, you might want to trial it across the entire workforce, or you may want to pick particular sections of the workforce to run the trial with. During the trial period, it's essentially a chance to adapt and adopt your hybrid working model. So you can make certain changes, you can sort of iron out any teething issues that may arise. Following then the end of the trial period, you should get employee opt-in or agreement. We appreciate that it's often not practical to reissue your entire workforce with new terms and conditions of employment. So one way around this is to sort of issue an employee opt-in similar to that you would issue in relation to the working time regulations. As I've said, it's likely hybrid working is going to constitute a change to terms of employment if it's going to be implemented on a more permanent basis. So it is important that you do get employee consent. And then finally, then your hybrid working will be formally implemented. Or I suppose if it really has gone disastrously during the trial period and you just feel that there's no way it's actually going to work, then you could end it without obviously needing to implement any changes to terms and conditions. You cannot view hybrid working as a one-size-fits-all approach, and it's really important that it's tailored to your organisation. So as you'll see from this slide, before you would actually go about implementing a hybrid working model, you're going to have to do a bit of research into your organisation and really sit down with key stakeholders, with different individuals across different business functions, and think about the pros and the cons of hybrid working. I appreciate that a lot of the information on this slide is fairly self-explanatory. However, what you will probably notice is that a lot of the advantages for employers actually translate across to be advantages then for employees as well. So for example, a big advantage for some employers is going to be the potential to make considerable commercial property savings if they can perhaps reduce a floor in the premises that they are letting. By the same virtue then for employees, if they're not having to commute into the office every single day, they're going to make savings on parking and on travel as well. So as you can see, there's lots of different advantages and disadvantages. And by doing this pre-planning before you actually dive in and implement hybrid working, it'll also enable you to highlight potential risk areas and potential areas that may not be well received by employees, and it will enable you then to put strategies in place to help deal with this. So one area that we're seeing from a lot of our clients is concerns about junior staff members and how they can A, be supported, and B, be performance managed. So if you really think about this before you dive into a hybrid working model, you can put in place very practical strategies, such as even a buddy system with a more senior team member, or weekly check-ins with managers, and team meetings as well. And we would typically advise, if you are doing hybrid working, that you either arrange where there's one day each fortnight where the whole team is either in the office together to have a meeting, or else you just run all your meetings via Zoom. So it's just small things like that that will ensure that you're not creating a two-tier workforce, as they say, whenever you are running your hybrid working model. You'll see from this slide, there are a whole myriad of possible implications of implementing hybrid working. As I've mentioned, and as Zara mentioned at the start, hybrid working does require careful consideration and careful planning. So you'll note from the points on the slide, the potential implications stem across the full spectrum of the employment relationship, from health and safety to performance management, right the way across to data security. I don't have time to delve into them all for the purposes of this webinar, but I'm just going to pull out a couple of the areas that I think a lot of employers can overlook. And the first one is actually data security. So I would point out, first of all, that whenever you have employees working remotely or working from home, the data protection obligations under the GDPR and the Data Protection Act 2018 do still apply. So they're not limited to just when employees are actually on your premises. Arguably, whenever you have employees working between the office and remotely, the risks of data breaches and even accidental data breaches occurring do increase. This can be because employees are transporting personal data between their homes and the office, and even if they are living in shared households. And I appreciate this could be more pertinent for younger staff members who perhaps live with friends. There is a risk, if your employees are on calls, that other members of their households could be hearing confidential conversations. And again, this would be particularly dangerous if other members of the households work, for example, for competitors or other organizations within the same industry. There's easy practical solutions to help improve data security if you are going to implement hybrid working on a more permanent basis. And I appreciate throughout the past year and a half, you probably have revisited a lot of your data protection policies, and you probably have already provided updated training. But if not, now is a good chance to revisit that. And it's particularly important that employees are aware of how they can report data breaches or data incidents should they occur. Another related data protection matter is actually in regard to overseas working. So you're going to have to be mindful that some employees, as hopefully the travel industry starts to reopen further, ask to work overseas. So if employees are working from within the UK or even within the EU, there aren't really any additional data protection obligations under the legislation that you would have to be aware of. The picture is very different if you do get employees then who ask to work in other countries extending outside of the EU, because you have additional obligations under the data protection legislation for personal data to be transferred to those countries. And again, I'm not going to go into that in loads of detail today, but it is just something that you are going to have to be mindful of, and you are going to have to ensure that you have a clear and consistent approach in relation to working from those countries. Another big area that has really generated quite a lot of media attention lately is in regard to working time and employee well-being. And this stems from calls for a right to disconnect to be introduced. So most recently, there was a report published by Autonomy think tank, and it highlighted that while there have been a lot of benefits for employees working from home, it has also led to what is called an overtime epidemic, whereby employees are increasingly working beyond their working hours, and they're not really getting a proper distinction between their work and home life. So the report calls for the employment legislation, the Employment Rights Act, or the Employment Rights NI Order 1996 in Northern Ireland, to be amended to prevent employees A, having to respond to work requests outside of their working hours, and B, not to be subject to any detriment for failing to respond to work requests outside of working hours. So essentially, this is just calls for the right to disconnect. At the moment, it's unclear how this would actually work in practice. It could be that if it was implemented, that employees would have an opt-out similar to that for the working time regulations, so that then employers would have a degree of control as to whether employees can take on work outside of working hours or not. And it also gives employees then the chance to say, no, actually, we understand that we might have to work beyond our working hours and we're happy to opt out. So that's, again, something to be mindful of, and it sort of shows a direction of travel as well, even in relation to employee well-being and employee mental health. And obviously, if your employees are working excessively and this is affecting their mental well-being, this will have an impact not only on their productivity, but also on staff morale. So then you can run into employee relations issues there, and also perhaps employee retention issues too. So the last slide today on hybrid working then is some considerations if you are going to permanently apply hybrid working and you want to develop a policy. Now, I would point out here that you don't have to have a policy per se. You could have hybrid working guidelines. However, if it is going to be implemented with a degree of longevity, you're probably better to have a policy in place. But we would always advise that any policy is non-contractual in nature, because this just gives you then the ability to freely change it. And as hybrid working is a continually evolving area, it's likely that the policy will have to be tweaked and adjusted as hybrid working pans out. Another option for a policy would be to actually read across your entire suite of existing employment policies or your staff handbook, and then make specific changes to those to cater for hybrid working. Again, this is something that you maybe will do down the line. We sort of coin it as the policy drafting as a practical outworking of adapt and adopt. So if you put in place a standalone policy for the time being, you can then adapt your hybrid working arrangements, find out what works well, and then when it's a bit more set in stone and you're ready to permanently adopt specific things in regard to hybrid working, then you could read across your existing policies. Moving on then now to another massive COVID-derived topic, so vaccination. The COVID-19 vaccine has been and continues to be continually evolving, and it's uncharted territory for both employers and employees. And understandably, this makes it very, very difficult to navigate. You'll probably be well aware of the phrase "no jab, no job," which dominated the media a few months ago in relation to Pimlico Plumber's decision to only recruit individuals who had received both vaccinations. This generated widespread concern amongst employees who feared that they could be mandated to get the COVID-19 vaccine by their employers, especially as some large technology companies in the United States, including Google, have stated that they're only going to permit fully vaccinated individuals to return to the office. However, this doesn't seem to be a huge concern in Northern Ireland any longer, and perhaps due to the generally good uptake for the vaccine, and also by guidance issued by the Northern Ireland Equality Commission and the Labour Relations Agency, which highlights the particular issues and, I suppose, concerns about implementing a mandatory vaccination policy, given the amount of legal and also commercial risks that it could generate, as you will see from the slide. So I'm not going to go into these in too much detail, but you will note that there are quite a few employment risks there by imposing a mandatory vaccination, not least discrimination. And I would point out as well that employees don't have to have any qualifying service to bring a discrimination claim. So again, this widens the scope. And even in Northern Ireland, for unfair dismissal claims to be brought by employees, they only need 1 year's qualifying service, whereas in Great Britain, this is 2 years. So as an alternative then to mandatory vaccination, another approach would be to encourage employees to obtain the vaccine. If you are concerned about COVID spread in the workplace following a return to the office, obviously you're going to want to carry out a risk assessment before you do this, and you'll have to have a careful strategy in place in relation to communication as well. As you'll see from this slide, a good way of encouraging vaccination is just to provide your employees with information, and the information should be accurate, consistent and factual. And this is echoed through the guidance issued by the Labour Relations Agency in Northern Ireland. It suggests that you have a clear communication strategy with factual and reliable information that points to official sources where employees can read verified information about the vaccines. A big concern that we're seeing from our clients is that there's often Chinese whispers through the workplace, and then this really can generate concerns with employees that are perhaps unwarranted in relation to the vaccine. That being said, employees are going to have concerns about getting the vaccine, and it's important that you do deal with any concerns that are raised sensitively, especially as they may be completely legitimate and they could be based on protected characteristics such as a disability, or even something if some employees have a particular food allergy, they may be advised not to get the vaccines because of certain ingredients that is in them. I'm going to pass you back over to Rob then. He's going to chat a little bit more about the halfway house then between encouraging vaccination and mandatory vaccination.
So Johanna's just touched on encouraging vaccination, be that by pointing to guidance or sources of information. This is the slightly more active role in incentivizing employees to get the vaccination. And this is something actually businesses are already doing for customers in the UK, Asda, Uber, Deliveroo, just some examples of businesses who are offering discounts to customers who can prove their vaccination status. Now that comes with its own risks to consider, but the position on their employees is slightly different. And I suppose it's something that in recent months was probably more seen in the US, where companies were coming out and effectively offering cash in some cases for employees to get vaccinated. The position in the UK hasn't really been tested, certainly not legally anyway. But again, there are risks, and you will see some of them on the slide. Again, our recommendation for clients is always to start with the encouragement pathway. And then if you're going to move towards incentivizing, there are things you need to consider. I guess it's better to encourage and incentivize than mandate, but it's still risky. One of the things that, again, has been touched on already by Johanna is this risk of discrimination, which is a day one right for employees. And again, that's because there are maybe individuals in your workforce or your clients' workforces who, be it because of a disability or a religious or philosophical belief, or even through maternity or pregnancy or things like that, simply cannot or are unwilling to get the vaccine. And then you may have a fallout where you are seen to be favoring employees who can. I guess the other side of the coin is you don't want to go back to this two-tier workforce whereby some of your employees may have jumped at the chance to get vaccinated, didn't need any coercing at all, and then they, probably quite rightly take umbrage with the fact that somebody who maybe just digs their heels in or drags their feet slightly then benefits in a way by being that way. So it's certainly a piece to consider carefully. It's not something that we encourage people to rush into. You always have to be mindful of the potential pitfalls. And as it says at the bottom of the slide there, alternatives are available. You can continue, as I'm sure everyone is doing, to encourage things like social distancing, hand washing, controlling numbers in the office, lateral flow tests, things like that. I guess though, and it's leading into the next slide, one of the sort of arguments employers can make in terms of being able to justify incentivizing vaccination comes under the health and safety obligations and duties that employers have in order to ensure that the workplace is safe for employees. But we'll move on to that slide now. And again, as I touched on there, employers in Northern Ireland are under a legal duty to ensure that employees have a safe working environment. And so arguably, encouraging, incentivizing, and in some cases even mandating employees to get the vaccination can potentially be considered a reasonable step to take in order to meet those duties. It will probably, as these things always do, depend on a sort of case-by-case basis, and certainly for certain employers, it will depend on the sector they operate in. Healthcare being the obvious one, where even pre-COVID, your employment depended on the fact that you got certain vaccinations. Other side of the coin, it's potentially slightly harder to insist that employees get a vaccine if they're in a job that actually doesn't require them to be either in the workforce a lot or even at all if they're working remotely, or coming into direct contact with other employees. So again, it's a question of reasonableness and sitting down and considering your options. That middle one, the human rights element, which was touched on in one of Joe's previous slides, again, under Article 8 of the Human Rights Act, individuals have a right to private life, and there's a question, although again untested in law, are you as an employer effectively interfering with that or violating that by requiring your employees to get vaccinated? Something that may well come out in the washing case law. It's probably a bit of wait and see. And again, the final of the three elements at the bottom there is just, again, be mindful of the discrimination possibilities. If you are saying, in order to comply with our duties, we require you to get vaccinated, there may be people who simply aren't able to get it, be it because of a medical condition or are in a position where a belief is stopping them getting it. So again, as with all things, it's the sort of measured and considered approach that we recommend in these cases.
Just quickly want to touch upon data protection considerations of collecting and processing vaccination data. Again, this is something that has the scope to massively expose employers if they get it wrong. You'll all be very aware of the hefty penalties under the data protection legislation that can apply. And this is particularly relevant to vaccination data because it will constitute special category data under the data protection legislation because it relates to an individual's health. So firstly, before you decide to process volumes of data relating to employees' vaccination status, it's prudent to carry out a data protection impact assessment. And this really just makes sure that you can have considered your rationale and your legitimate basis for needing to process this data. And on the topic of lawful basis, because vaccination data constitutes special category data, you will need to show that you have a lawful basis for processing this under Article 6 of the GDPR, and that you also can satisfy an additional processing condition under Article 9. Now, I appreciate that this could all sound like double Dutch. The data protection terminology is not the most user-friendly, but essentially what this means is that you have to have a lawful basis under Article 6. So for example, your legitimate interests could satisfy that. And it's likely that your legitimate interests will be protecting the health and well-being of your employees and also ensuring that you have a safe working environment in accordance with your obligations under the health and safety legislation applicable to Northern Ireland. The additional processing condition is where it gets a little bit more difficult. However, there is scope for some of the conditions set out under Article 9 to be relied upon in this instance. And probably the most applicable ones are going to be that the processing is necessary for the performance of your rights and obligations in connection with employment law. And secondly, for public health purposes. Obviously, COVID-19 is a public health crisis, so it's likely that public health grounds would satisfy this. But again, under the data protection legislation, there's core data protection principles that no matter what personal data you're processing, you have to adhere to. So one of these is that you must process data for no longer than is necessary, which means you really should only retain vaccination data for as long as you deem relevant to ensure that you are safeguarding a safe working environment and providing, I suppose, a workspace that's compliant with government guidance. You also need to be transparent with the data that you are processing and collecting from your employees. And this is in line with the transparency principle. So it may be the case that going forward, you're going to have to review your privacy notice that is issued to employees to let them know that you may need to collect additional data relating to their vaccination status. Same time, in mind that there's other means of ensuring compliance with your health and safety obligations that may not actually require vaccination data to be processed. So obviously there's social distancing, sanitizing stations, and things like that that are very straightforward and very practical. Another way around having to potentially go through the whole rigmarole of finding the lawful basis for processing and carrying out an impact assessment is if you simply conduct a visual check of vaccination status. Again, you would have to, I suppose, have a basis for doing this, but if you're just conducting a visual check, strictly speaking, you're not actually processing any personal data. So the obligations that I've talked about under the data protection legislation wouldn't really be triggered. In relation to sharing vaccination data with staff, this has come up a few times with some of our clients whereby colleagues are wanting to know who else has been vaccinated in their teams, and particularly those who are perhaps very COVID conscious and apprehensive about coming back to the workplace. Fortunately, the ICO has actually directly addressed this point, and they have stated that ultimately an employer needs to respect its duty of confidentiality to all of its employees, and it should not routinely be disclosing vaccination status. However, it could let employees know that not all of their colleagues have been vaccinated, but it can do this without actually specifically identifying the individuals that haven't received the vaccine. So that's really just a whistle-stop tour of some of the data protection considerations. There's a whole host of other issues that could arise if you are collecting and retaining vaccination data, but ultimately the main takeaway for this is familiarize yourself with the data protection principles, and really think about why you are going to need to process vaccination data if this is something that's perhaps on your agenda. Moving on then, to practical tips then for managing vaccination strategy. So a lot of these we've already touched upon. I can't really reiterate enough how important it is to have a good communication strategy. A communication strategy that is clear and consistent so that your employees know what you want to achieve and also know that you're there to support them. COVID-19 has brought widespread challenges for people on a professional and a personal level, and your communication strategy is a chance to really highlight that you're there to support your employees and also encourage their productivity and encourage team morale, and I suppose to an extent as well a return to normality.
Just to piggyback off that, I think communication can't be overstated, and it's actually quite an easy piece for employers. For example, if you have existing employee forums or things like that, where you maybe run by proposed changes past a sort of select group of employees who can then feed back to the wider workforce, that's a really easy step to take if you are thinking of bringing in new policies or even thinking about, incentivizing or encouraging vaccination, just as a a sounding board, if nothing else. And again, it's the kind of thing that we encourage clients, if they have those forums in place, or even if there is a union, a recognized union in place, don't be afraid to have those conversations, because they can't fail to help.
I suppose another key point from this slide really is the vaccination policy. Again, there's no one size fits all approach in terms of a policy. It'll apply differently to all organizations. In fact, some organizations may decide that they don't even need to have a vaccination policy, depending on their stance. However, if you are planning to encourage or incentivize vaccination, it's always a good thing to have something documented, not least in the event that some employees took issue with it. At least then you have something on paper that you can rely on, that reflects your position. Again, the level of detail of a vaccination policy can vary. It's something that we recommend, if you are thinking of putting in place, that you do obtain specific legal advice on. Again, risk assessment, just ensure you have an updated risk assessment in relation to vaccination. It may highlight that you're able to meet your health and safety obligations through other means, such as testing, social distancing, sanitizing stations, etc. All the things that Rob and I have already mentioned. I think then that wraps us up in relation to the return to work update. I have one last slide on just a couple of general employment updates that I'm going to let Rob chat you through.
So, as we said at the start, we touched on the most sort of topical and relevant issues as regards a return to work, but that's not to say that despite COVID, there haven't been other updates in employment law, and I'm going to go through those now. What you may discover quite quickly is there's a common theme here, which is wait and see. But I suppose in terms of the first one there, parental bereavement leave, that's something that is actually already a statutory right in GB. In Northern Ireland, there is a bill going through the Assembly to bring in that same right, and that effectively is a right to statutory time off and pay if you are in the unfortunate position of losing a child or having a stillbirth. Again, as is often the case in Northern Ireland, critics have argued that actually the current legislation in GB doesn't go far enough, nor does the bill in its current format. And what some campaigners would like to see is actually this being a right for essentially everyone in Northern Ireland who loses a close relative or partner. It remains to be seen whether there will be changes to the bill, but certainly some of the parties at Stormont have already come out and said they don't think this bill goes far enough. Similar sort of theme with gender pay gap reporting. So gender pay gap reporting has been on the cards in GB since 2017, and effectively what that does is oblige employers with over 250 employees in their workforce to publish details of their gender pay gap. Northern Ireland, again, is in a slightly different position, not least because certainly previously statistics suggested that actually Northern Ireland had a negative gender pay gap. That is certainly not the norm. But again, because of some of the difficulties that the Assembly faced in terms of being up and running, even pre-COVID, legislation in 2016 provided for the introduction of gender pay gap reporting in Northern Ireland. Sadly, that has not yet been implemented, and actually, in sort of trying to find out when that is likely to come in, we couldn't even get an indication. Again, though, the proposed legislation and regulations go that one step further than its GB counterpart. So in Northern Ireland, it is proposed that actually employers will have to publish details of not only gender, but also things like ethnicity, disability, and just again, go that slight bit further. The PSNI holiday case, I'm sure you've heard in the news, holiday pay and holiday pay calculation has been all the rage over the last sort of 18 months. And as practitioners, we were perhaps boringly quite excited when the Supreme Court was listed to hear the PSNI Agnew case in September. And at the last minute, they pulled the rug out from under us. And the reason they did that was because the parties are now actually in mediation. The likelihood is that will settle. And frustratingly for practitioners, the terms will be confidential, so we will be without a settled position on holiday pay. And again, one of the sort of downsides of that is that at last count, there were close to about 100,000 cases relating to holiday pay currently stayed in the tribunal in Northern Ireland, essentially awaiting this final decision. How those get moving in the absence of a clear outcome, I don't actually know. The tribunal already has a significant backlog across the board in terms of cases because of COVID. And to sort of slightly jump back to the beginning, we haven't actually seen many cases related to furlough, be they unfair dismissal related or what have you, but we imagine those are in the system somewhere. They're just taking their time to come through. And then the final one is probably something that you guys will be much more familiar with in terms of the changes to IR35 off payroll working regulations that came in April last year. And the sort of difficulty we face in the sort of pure employment law sphere is that while those IR35 regulations consider employment status for tax purposes, they are intrinsically linked, although not exactly the same, to the tests that the courts will consider for pure employment status purposes. And actually what we have seen recently in some cases is where, because the determination ultimately rests with the client, which in most cases is the employer, individuals who are being considered employees for tax purposes are saying, okay, well, if that's the case, I essentially want to have all the benefits that attach to employees under employment law if you're going to consider me one for tax purposes. Now, in a lot of cases, it doesn't work that way. But we have seen a sort of increase in not necessarily claims, but certainly individuals coming out and saying, how does this affect me? Or actually, you know, you've reached a status determination, I disagree with it, but if you're going to insist on that, well, then I would also like to get some benefits out of it. HMRC have sort of adopted a bit of a wait and see approach in terms of penalties. So again, because the onus is on the employer to get it right, if they get it wrong, they are on the hook for any penalty that is ultimately payable. Certainly from our perspective, we would appreciate further guidance because the current system is particularly unclear. There is a status determination tool known as the CEST tool, but actually in sort of running through that ourselves, we have noticed, and I'm sure clients or yourselves will notice the same, that a lot of the times, you know, the answer that tool churns out is either inconsistent with the circumstances that you are faced with, or actually it doesn't even give you a determination. So again, more guidance would be helpful on that one. And again, just to sort of go back to the furlough point in terms of fines and things like that, something I should have pointed out at the start, in terms of what next for furlough. At some point, we would anticipate that HMRC will come calling in terms of some of the claims that were fraudulent, or the sort of abuse of the system that certainly seemed to be prevalent in the early days. I think at last count, the government and the HMRC had sort of factored in about 10% of all claims were either going to be fraudulent or mistake. Now, when you think that actually all told the amount of furlough assistance that's been paid out is somewhere in the region of £60 billion, that is not an insignificant number. And knowing HMRC as we do, we would be stunned if they didn't come calling at some point for that. So that's another wait and see. But again, that was just a real run through some of the other updates. But at this point, I think we'll try and answer some of your questions that have come through.
Great. Thank you both, Rob and Johanna, for such a comprehensive update. And there's just so much food for thought in there. It just makes me think COVID is the gift that keeps on giving in terms of this, isn't it? Just we keep on going into new territory. A few questions have come in. First one, not sure if this was picked up correctly, but can you maybe clarify what you meant by a hybrid working policy not being contractual in nature?
Yeah, no problem. So typically, whenever you introduce employment policies, they'll either be contractual in nature, whereby they're binding on all employees, similar to the way an employment contract is. So if you want to make a change to it, then you have to get employee consent. The alternative is you introduce non-contractual policies, which are essentially guidelines. They're essentially best practice for employers to follow, but employers are able to then freely amend those policies without having to get employee consent because they don't have that contractual force.
Great. Okay. Hopefully that has clarified that one. The next question, how are employers that are requesting mandatory vaccinations planning to win if they are taken to court? And what is their argument for demanding that staff have it?
So I suppose first things first, you're never quite sure if you ultimately find yourself in court how things are going to go. We try and avoid that at all costs because you sort of lose control once you're in front of a court or tribunal. But I suppose it sort of goes back to something I touched on in terms of that proportionate means of achieving a legitimate aim, and that would be the sort of health and safety duty. So in order to meet our duties, we think it's reasonable and proportionate that you're vaccinated. I suppose again, it's a case by cases thing. If you're in the healthcare sector, it's probably easier to argue that. Again, if you are in, just off the top of my head, IT or cybersecurity, whereby it's sort of more remote and that this has never been a thing in the past, it's probably a bit of a stretch to say that actually this is reasonable, where an employee could say, well, actually, for whatever reason, I can't or I won't take the vaccine, but I tell you what, I'll submit to these tests regularly. I'll wear a mask. I'll social distance. How effectively is that not enough for you? So again, and it's a bit of the usual legal cop out. It depends, but it really comes down to that. How reasonable is it of you to request this or mandate it?
Okay, and that's interesting. So if the employer decides, okay, for those that aren't vaccinated, they want evidence of tests, is that something that the employer can insist on?
Yeah, I suppose, again, there's a whole host of considerations there that an employer would have to consider, not least data protection. Again, it's going to depend on a whole host of factors: the nature, the size of your organization, the amount of detail that the employer is requesting. One way around it perhaps is to do an anonymous survey to just get a sense of how many employees within your organization are vaccinated. And I guess that could be justifiable on an anonymous basis, insofar as it will assist your organization then in preparing for a return to the office, and I suppose in mapping out how many employees can be in the office on given days, for capacity purposes and social distancing and all that good stuff. So.
Thanks, Joanna. It's funny, the next question was about a questionnaire to staff. So the question was, is it okay to send a questionnaire survey to all staff to determine how many are vaccinated? So you have said there that it's okay to do it on an anonymous basis.
Well, it's probably the safest way to do it.
Mm-hmm.
Again, there's going to be other implications there too, even, optics, things like that, and how it's perceived by your employees. Some employees may take offense at it and think, well, why am I being asked this? It's my private life. I don't need to tell my employer if I've been vaccinated or not. So again, it boils down to communication strategy, I think. Carefully explaining why you need the information, explaining it's for everyone's health and safety, things like that. So yeah, it's hard to give definitive answers in a lot of this.
I know. And would it be okay to share the results of an anonymous survey with employees, or should you be collecting that just for employer data?
Rob, I don't know if you have any particular thoughts. I mean, I suppose it depends on the way you're sharing the results. If you're just doing it across the entire workforce.
I think the worry there is that depending how you record it or show that, it may be possible for people to work out who is who. So it's not without risk. I think you'd really need to consider how and why, and perhaps also when you show that. Again, it will depend as much as that is an unhelpful answer.
Yeah. Okay. Another question then, if only a few members of the workforce have refused to take the vaccine, is it acceptable to insist that these employees work remotely at all times in order to protect both themselves and also the rest of the workforce?
Personally, I think it's difficult, again, because it's sort of that needs of the few, needs of the many. And again, you might, as an employer, say, well, it's a health and safety duty. That effectively is it. And we have to ensure that everybody is protected, including you, even if you haven't been vaccinated. Again, though, an individual who can't or won't get vaccinated might quite reasonably argue, well, everybody else is vaccinated anyway, so surely the risk is lower. Again, I'm willing to wear a mask. I'm willing to submit to tests. And I think if you're an employer, it would be slightly difficult if an employee is waving a negative test in front of you to say, no, we still require you to work at home. I think that's a difficult one because, again, you're sort of looking at a two-tier workforce. And just by the nature of it, somebody who's unable or unwilling to take the vaccine will more than likely take umbrage with the fact that they are then being excluded because of that. So not without risk. I think you would really need to be pretty ironclad on the rationale for that. And in a lot of cases, I don't think that's there.
Yeah, okay, thank you. Another question, can we require all new joiners to be vaccinated as a condition of employment? I think you touched a bit of that, Joanne, earlier.
Yeah, again, a grey area. It's untested, probably less risky to do that than to mandate it amongst the current workforce. But as Rob's touched upon, there's still a discrimination risk there as well. Certain employees or certain applicants, may not be able to get the vaccine for perfectly legitimate reasons, and then you are opening yourself up to a risk of a discrimination claim. But yeah, I would say ultimately it's less risky, but as we've said in our slides, we would still just go with the approach of, firstly, you want to try and just encourage employees to get the vaccine if that's the stance you're going to take to help fulfill your health and safety obligations.
Okay. Can employees still make flexible working requests even if we have introduced hybrid working?
Yeah, flexible working it's a statutory right. It's completely separate to, I suppose, I was going to say the more fluffy, but well, less regulated hybrid working that's sort of panning out at the moment. So yeah, it's a completely separate right.
Just on that, there is a consultation in GB at the minute in terms of flexible working. Currently, you have to have been employed for 6 months with your employer before you can make a flexible working request. There's a very prescriptive statutory process that you go through to do that. And there are also sort of statutory reasons where an employer could refuse it, for example. The other thing is that you can only make one every 12 months. At the moment, and in GB they've kind of accepted that the current framework isn't great. COVID will have accelerated the sort of desire and recognition that it maybe needs to change, simply because flexible working requests previously were, I think, treated with a bit of mistrust by employers, rightly or wrongly. But effectively, where they were maybe in the past able to say, oh, we can't allow this because it simply doesn't work with our business model or whatever. A lot of employees have spent the guts of 2 years working from home now, so it's slightly disingenuous when they have just done that to suddenly turn around and say, oh, we can't because X, Y, Z. Some of the things they're looking at the consultation is making it effectively a day one right, and also the ability to make more than one in a year. And they're also looking at overhauling the reasons that an employer can potentially rely on to reject a request, with a view to a bit more of a meet in the middle approach. Again, that's at consultation stage, so I think we sort of keep a keen eye on that one. While it is GB, it's the kind of thing that Northern Ireland will more than likely follow in behind. But again, that point I touched on in the last slide there, Northern Ireland legislation has a habit of going that one step further. So it's certainly something to keep an eye on for employers.
Great. And the last question we have at the moment, what should we do about employees who ask to work from their holiday homes? That maybe Donegal or maybe Spain, whatever.
Yeah, again, this is another question that we're seeing come up a whole lot. And there's just so many things to consider. I suppose not least where the holiday homes are located. There's a bit of a difference in someone asking to work from Portrush or Donegal, or someone asking to work from south of Spain. So yeah, there's lots of things for employers to consider. I think probably the main thing for employers in this regard is to ensure that the approach is fairly consistent and it's clear, and that employees know what is allowed and what isn't, and that ideally should be communicated at the outset. There's a whole host of other issues as well. Taxation, I'm not going to go into tax. There's also data protection, touched on that earlier. We have received an adequacy decision, which streamlines the whole process of if data is moved between the UK and the EU. So arguably then, if staff were working from destinations within the EU, there aren't really going to be data protection implications for doing that. But there may be sort of, I suppose, other softer implications in terms of performance management, contact between team members, things like that, that would have to be factored in, and time differences as well. Obviously within the EU, that's not too much of a factor, but I do think it could take employers down a rabbit hole that's a bit difficult to get out of. So again, it's, I suppose, just treading with care and not overcommitting. I think with the hybrid working arrangements in general, it's important to sort of ease yourself in slowly and don't dive in. Don't say, yes, of course, you can work remotely, you can work from your holiday homes, you can do whatever, because it'll be hard to backpedal from that. I suppose another issue as well that I was sort of thinking about in this regard is if you allow this, you could run into then employees saying, okay, well, we're taking a week's annual leave, but we're going to be in Spain for 2 weeks and we'll work from there for a week. And again, it's leaving the scope for employees and maybe don't have holiday homes to say, well, essentially they're getting 2 weeks holiday. Mm-hmm. So there's a whole host of issues there. It's quite difficult to provide, again, a definitive answer on that, but I suppose if it's something that's cropping up more and more, don't be afraid to obtain specific advice, and to even just internally discuss it as well to gauge viewpoints.
Great, I think that's really useful. Another question has popped in. What can I do about employees who don't want to come back into the actual workplace?
Again, we've sort of touched on that. I guess it will depend on the individual's circumstances. I mean, you would assume that it is because they either have, or a family member has, maybe an existing medical condition, or maybe it's just a nervousness around COVID generally. Or maybe because they know that certain co-workers, for example, are refusing to get vaccinated, and they're not willing to take the risk. I suppose it's a bit of an employee relations piece. You know, it's sitting down and saying, okay, tell us your concerns. How can we perhaps help alleviate that, be it signposting to advice or things like that. But it's the kind of thing that has the potential to get quite muddy quite quickly, depending how you handle it. We certainly wouldn't be saying that you go in like a bull in a china shop and just say, well, effectively our position is you have to come back, because that helps no one. But we've harped on over and over about it. It's sort of a case by case thing, albeit you wouldn't be sort of prioritizing somebody's situation over another's. While you can't have a one-size-fits-all approach, it's that question of sort of reasonableness and just being understanding, I think, at the outset, and signposting, again, encouraging, not necessarily incentivizing. But ultimately, I think one thing the pandemic has done, has a lot of people have had time out, not necessarily on furlough, but maybe just spending that more time out of the office, and have sort of decided, actually, maybe this isn't what I want to do. And you may find that actually it's possibly a convenient excuse for some people, although how do you go about exposing that, who maybe just actually don't want to come back to this particular job, and it's quite convenient for them to dress it up as, well, it's concerns over COVID. I mean, that kind of thing will probably come out in the wash if you poke hard enough, but again, it's the sort of sensitivity piece at outset.
Great. lots of really good advice, and that has brought us right up to our hour. So I'd like to thank both you, Rob, and Johanna, for such a comprehensive update. As I say, there's loads of food for thought in there. We've had a really good turnout today, and it stayed constant the whole time, so it's obviously an area that people continue to be interested in. Just as a final note to everybody, the second webinar in this series will be on the 28th of October, and it's on the topic of director's duties. So I hope that you can all join us again for that one. So just to wish you all a lovely afternoon, and thank you for joining us.